Thank you, everybody, for joining us today. My name is Noah Hodgetts. I'm a principal planner in the Office of Planning and Development at the Department of Business and Economic Affairs, BEA. And today's webinar is a review of 2025 land use law changes, summary of everything that passed in the last legislative session. Here's a list of all the different bills and topics we're going to go over today. I'm going to start by talking about some of the state permitting changes. Then we'll go through a number of the different planning and zoning statute changes. I'll then touch on a few of the building and fire code changes, and then finally wrap it up talking about the C-PACER bill, SB4. So with that, we'll just do a high-level overview to begin with of state permitting changes. Sorry, I neglected to mention it at the beginning. We're not going to do questions due to how much content we have to get through. There is a chat box, though, that you should be able to put information in if you do kind of have a thought that you want to save or share with the group for later or anything. My contact information is also included at the end of the slide deck if folks do have specific questions they want to follow up with after today's webinar. So the first thing, as I said, we're going to go through today is all the state permitting changes. As folks are probably familiar, there were a number of changes made in House Bill 2, the budget trailer bill. Namely, most of the changes around permitting are found in sections 1 through 15 of House Bill 2. The most significant changes are that the ecological reviews conducted for compliance with the Endangered Species Conservation Act and the Native Plants Protection Act, which were previously kind of shared between three agencies, between DNCR, Fish and Game, and DES, have now all been moved and consolidated to DES taking the lead on all of those reviews and completing those reviews within a 60-day review period. Along with that change, DES has also published a new data check tool for applicants to screen for the presence of threatened and endangered species, critical habitats, or exemplary natural communities. House Bill 2 also creates a new provision for alteration of terrain permits for areas that are encompassing less than 150,000 feet, and those rules will go into effect January 1st, 2026. And those are only covered for areas not in the shoreland. And unlike the typical AOT permit, those will be pretty much kind of a, not quite immediate, but pretty quick turnaround notification of eligibility to all applicants. And then a few of the other changes, we're not going to go through them in detail, but I have linked to kind of each of these topics in the slides, which you should have all received a copy of. There's a number of different application fees for most DES permits, things like wetlands permits, again, alteration of terrain permits, subsurface bureau, septic permits, so on. And so there's some fee increases for all those permits, other permits, and other programs as well. And the reason for this was so that going forward, all those permitting programs are not dependent on general funds and can be administered self-sufficiently. So those are the bulk of the permitting changes in House Bill 2. Some of the other permitting changes are SB 74 creates a new annual reporting requirement for all state permitting programs beginning April 30th, 2027. This encompasses any permitting program that's affecting the issuance of permits on real property. So this will, for the first time, we'll start to have data on things like how many AOT permits or wetlands permits is DES issuing, how many driveway permits are being issued, as well as kind of what is the turnaround time on the issuance of those permits. Finally, Senate Bill 153, related to expedited driveway permitting of major entrances for residential use of 20 or more units, was passed. And this builds on the 2024 House Bill 1202, which mandated that DOT issue driveway permits for non-major driveways within 60 days. So this now creates a optional expedited permit process for applicants for major driveways for 20 or more residential units. If they want that same 60-day review period turnaround, they can apply for that at a cost of $120 per unit. And that process just took effect actually a couple weeks ago on October 5th. Again, the link to all the documents for that new process are included here. So that's a wrap up, a big picture of the state permitting changes. Next, we'll get into going through some of the planning and zoning bills. So the first bill, again, we're going to talk about House Bill 2 again for a second, because from the planning and zoning perspective, House Bill 2, a lot later on in the same bill that I just talked about a second ago, sections 209, 214 outline the creation of a new partners in housing program at BEA, along with a new process for municipalities to designate and expedite permitting of municipally owned land for residential purposes. Now, this is modeled after what the city of Lebanon did. They took 2 lots on Barrow Street, on a dead-end street just south of 89, and they are currently in the process of turning that into a 5-unit cottage court development. There's a picture on the right of what one of those cottages will look like. Under this new process in House Bill 2, a Board of Selectmen will be able to send a list of municipally owned real property to the planning board and make a determination if those properties are in their judgment appropriate for development for residential use. Then once the Board of Selectmen has made that determination, they'll then send that list on to the planning board, who may then kind of put their further stamp of approval on it of those municipally owned properties being appropriate for developmental use. And then they'll send that list on to my shop, to the Office of Planning and Development, OPD, description and address of those properties. And then, as I'll talk about in a second, we will then, Office of Planning and Development will then publish a list per the requirements of 12-055 of all municipally owned properties that have been deemed appropriate for residential use. And then the other kind of, so there's the reporting requirement. The 2 other requirements here are, first, that by select board and planning board making a determination that those municipally owned properties are appropriate for residential use and submitting that description to OPD, that means that those properties become eligible for expedited review and approval via the minor site plan review process. So for communities that already have authorized expedited review through minor site plan, they won't need to get any additional authorization from their legislative body for minor site plan review. If they haven't already expressly authorized minor site plan review, the local governing body will have to vote to authorize that. either way, once the expedited review process is authorized in the community, and a developer comes forward with a proposal to develop housing on municipally owned land or leased land, that application will then be able to be accepted and approved in one planning board meeting without a public hearing unless requested by the applicant, abutters, or any other holders of any other conservation or preservation restrictions on the property. Idea is that it will significantly speed up the permitting process of housing on municipally owned land. As I said a second ago, OPD also has a reporting requirement under this section of House Bill 2. We have not received any applications yet, but look forward to hopefully receiving some in the near future. The other part on here was that originally folks may recall that this Partners in Housing program was part of a different bill, House Bill 572, which had an appropriation attached to it for BEA to both administer the Partners in Housing program as well as to take some of the money through the Housing Champions program and put it towards basically development of these properties for housing. Unfortunately, like a lot of other programs, this program through the budget process did not receive an appropriation. So right now, like I said, the process does exist, but BEA does not have any additional funding to provide to municipalities as part of the Partners in Housing program. The other thing this Partners in Housing legislation does is that it expressly authorizes pattern zoning, which is permit-ready designs with appropriate zoning and regulations to speed the process of building high-quality infill housing that is compatible with existing homes in the neighborhood. The city of Lebanon is actually already doing this, so this just kind of codifies that you can do this in statute. In short, how it works is that typically, as kind of the definition is laid out in statute, you take kind of an existing neighborhood where you want to target infill development, and you create a pattern book of pre-approved building different kind of house plans that the community, after kind of community vetting, has decided it wants to see in that neighborhood. And once you have those pre-approved plans, again, it really expedites the process. Anybody can apply, assuming you've met all the other zoning requirements. You can then go ahead and pick one of those plans, assuming there are no kind of alterations to those plans. Pretty quickly move ahead through the approval process to construction. Again, the city of Lebanon did that, or it's the first community in New Hampshire to have developed their pattern zoning program. They're putting the finishing touches on that right now. And will hopefully, this piece of legislation will allow other communities to take advantage of pattern zoning throughout New Hampshire. The next bill, House Bill 92, is not going to apply to very many communities, but it simply clarifies that in cases where a community has a member that sits on both a planning board and a zoning board of adjustment, if the member sits on both boards and while on the zoning board, a matter has previously been gone before the planning board, it's either pending or has been decided by the planning board, that member then has to recuse themselves from voting on the matter when it's before the zoning board if they voted on that same matter or application when it was before the planning board. It's kind of interesting. The statute, originally the bill as introduced was going to require reciprocal kind of recusal. It only kind of talks about it in the sense of an application going before the planning board first. So if the application originates at the zoning board, there was no actual formal denial from the planning board, which kind of kicks off the zoning board process, say a variance application or such, then this, and then the application goes from the zoning board to the planning board, this language would not apply. Okay, so we're going to keep going. The next bill we're going to talk about is House Bill 168. This is, in the scheme of all the bills I'm going to talk about today, relatively minor, but still important for some communities, and just kind of good thing for people in the housing world to know about. So right now, municipalities have the option, if they so choose, to impose impact fees on new development to reflect the effect of development upon municipal facilities at the time of the issuance of the building permit. The Innovative Land Use Control Statute, if folks are not familiar, that's RSA 674:21. Section of that statute, paragraph Roman numeral 5, sets out kind of a very specific process and what type of facilities qualify for what an impact fee can be charged for and what it cannot be charged for. Currently, the statute says impact fees can only be assessed and used for construction or improvement of capital facilities owned or operated by, including and limited to, and then the statute goes on to list a number of different facilities, things like roads, water sewer systems, schools, municipal office buildings. However, previously the statute did not include public works facilities. So this bill simply adds public works facilities to the list of eligible capital facilities that a municipality may impose impact fees for to offset the cost of construction, to assuming that there is a reasonable relationship between the in other words, there has to be a nexus between the impact fee and the effect the development is going to have on that facility, in this case, a public works facility, that's going to necessitate charging such an impact fee. So that could be something like this development is going to, somehow increase the amount of plowing that the town or city has to do, which and salting, which creates kind of increased pressure on its DPW facility. It means they need to expand the facility or maybe create a new facility in a new part of town, so on. But there has to be that nexus in relationship. A municipality can't just, with this new authority, say, we're going to charge an impact fee for public work facilities because we want another revenue source to pay for that facility. So moving right along, now we're going to talk a couple of different roads bills, and I'm going to distinguish here between, or let me first give a little bit of a primer for folks that aren't in the roads, kind of deep in the roads statutes. So there's a number of different classifications of roads, from class Roman numeral 1 to Roman numeral 6. And then there are these things called private roads, which are not actually defined in statute, but are privately owned roads, in short. RSA 674:41 provides certain kind of process and stipulations of when a municipality can and cannot issue building permits on these different types of roads. Previously, a municipality, if a developer wanted to build on a private road, the governing body, again, the Board of Selectmen, would have to consult with the planning board and have them review and comment on the building permit application to make sure that they didn't have any issues with it being in conflict with any other planning board regulations, so on, so forth. House Bill 296 creates kind of a new part of a new kind of option if a municipality chooses to allow a governing body to issue building permits for buildings based on a new policy, a private roads policy, if the select board identify, or if the select board has basically concludes that this application for a building permit on a private road complies with this new private road policy. And in short, in doing so, they no longer, if for whatever reason, they no longer need to consult the planning board if they've enacted this new private road policy. So that's the first part of House Bill 296. That just took effect last month, September 13th. The second part of House Bill 296 is might actually be more impactful. I guess that remains to be seen. But where previously any appeals of administrative decision and other appeals, which were first had to be appealed to the Zoning Board of Adjustment, ZBA, previously there was no set timeline on how long somebody had, basically, how long the shot clock was for somebody to appeal to the Zoning Board of Adjustment for appeal of an administrative decision. It was really up to what was in each municipality's ZBA's rules of procedure. The second part of House Bill 296 amends RSA 676, Roman numeral 5, to put a 30-day clock, or a 30-day period on the period for how long appeals of administrative decisions may be appealed to the zoning board. And this is consistent with other sections of statute, including RSA 677:15, which has a similar 30-day appeals period for planning board decisions, which are directly appealable to Superior Court. Next bill we're going to talk about is House Bill 399. This doesn't actually make any changes to the process, but creates a new legislative study commission to study the New Hampshire Zoning Enabling Act. It's an 11-member commission. It has a broad mandate to study whether the grant of zoning powers in RSA 674:16 and the purpose of zoning in 674:17 to 23 is still needed today to address health, safety, and general welfare of the community, as well as to recommend potential revisions or removal of certain powers. The commission also has a charge of investigating the relationship between the zoning provisions of that zoning grant of powers, 674:16, and the subdivision provisions in RSA 674:35, which govern subdivision review process. That commission has had one meeting to date in late August. It's going to be meeting again next Monday for the second time. Those meetings are open to the public if folks are interested in attending. Just if you haven't heard, all legislative meetings, at least all House committee meetings, and this is a House bill originally, are meeting at Granite Place up the road from the Legislative Office Building, since the Legislative Office Building is currently under construction. The commission interim report will be due coming up very shortly on November 1st, with the final report due on November 1st of 2026. It's going to be really interesting, I think, to follow kind of where this commission lands. I myself actually have the privilege of being a member of that commission. It's been interesting so far. We started to take a deep dive kind of into the evolution of the zoning enabling statute since it was initially passed in 1925. Yeah, I encourage everybody to kind of follow along as that commission, does the work over the next 12 months or so. So next bill is House Bill 413. This was one of a couple bills that didn't make it to the finish line in 2024, but did get across the finish line this year. So for folks that aren't familiar, previously, as detailed in RSA 674-39, any approval basically had been exempt from changes to local land use regulations after the date of approval. So things like changes in the zoning ordinance, changes in the site plan and subdivision regulations, for a period of 2 years from the date of approval. And then if an application, so if a project had reached a kind of benchmark of actually active and substantial development, which is not a defined term in statute, is up to the planning board to define, but for all intents and purposes really means kind of, a stake in the ground. We're actually breaking ground. We're actually kind of into the construction phase of a project. Then a project received an additional kind of 3 years of exemption from any zoning changes and other land use regulation changes. And then once it reached substantial completion, again, not a term that's actually defined in statute, but is up to municipality to define it. Then, and if assuming that substantial completion was achieved within 5 years of approval of the initial approval, the project would then receive permanent vesting status, except for impact fees. House Bill 413 was trying to kind of respond to the fact that, in today's kind of landscape, with increased difficulty for many projects to receive financing, material shortages, just the fact that projects are just taking longer from the date of approval to actually starting the construction, to actually the length of construction, extended the period to reach active and substantial development from 2 years to 3 years, and the period to reach substantial completion from 5 years to 7 years. It also stipulated that that the approvals granted after July 1st, 2023, would be kind of subject to these new extended timelines. And while the statute doesn't actually say how approvals prior to July 1st, 2023 should be handled, the legislative intent was clear here to provide more time, not less time, for approved projects to be completed. So, if a project previously had that approved prior to 2023, had that 5 years of to reach substantial completion, it should still, it hasn't somehow, lost its kind of vesting status within that 5-year period to reach substantial completion. That still remains. The other thing this bill does is it limits the authority of zoning boards when they're acting as a local building code board of appeals, which, for those that may have not heard that term before, it's basically the board of appeals specific to hearing appeals of decisions of the building official on building code interpretations, as well as if a municipality has its own building code, appeals the administration of that building code. In some communities, they have a standalone building code board of appeals, but in many communities, the ZBA is fulfilling that role. So this part, the second part of House Bill 413, just says that the ZBA, when it's acting as a local building code board of appeals, can only hear appeals of local amendments to the building and fire codes. Any other appeals, so interpretation of state building and fire code, and that application will now go directly to the Building Code Board of Appeal. The State Building Code Review Board, which typically has more of the technical kind of expertise to make those evaluations of how the state building code and state fire code have been interpreted and applied at the local level. There's also some new language about expanding the authority of the Housing Appeals Board to hear decisions of that have gone to the Building Code Review Board, which typically could only go to the Superior Court to be heard. Now they can also go to the Housing Appeals Board. House Bill 457 is relative to zoning restrictions on dwelling units. This was really trying to address ordinances, especially in college towns, which sought to limit the number of unrelated persons that could live together. So this bill does two things. It limits the adoption or enforcement of ordinances that restrict the number of occupants of any dwelling unit to less than 2 occupants per bedroom. And it also prohibits adoption or enforcement of any ordinance based on almost any kind of relationship. So based on familial or non-familial relationships, marital status, occupation, employment status, or education status. I won't go on to read the rest of it. You can read that on the slide. But I guess what I want to point out here is that it regulates the relationship of occupants in a building or in a unit, and the number of occupants in a bedroom, but it doesn't actually regulate or mandate any kind of uses. So if a municipality wants to keep regulating, as a municipality often does, congregate living, lodging houses, sober homes, dormitories, or other group living as other separate land uses, it may continue doing that, and this bill does not affect any of that authority. This bill also doesn't affect the authority for a municipality to impose a cap on the total number of dwelling units in a building or the total number of occupants in a building. As long as, again, back to the first bullet, that kind of total number of occupants or total number of dwelling units in the building is allowing for at least 2 persons per bedroom. This bill also does not affect any fire or building code requirements. And this bill also took effect last month. So now House Bill 577, the ADU bill. I think most folks have probably heard about the ADU bill and are aware, kind of big picture, that it amends the existing 2017 law by requiring both attached and detached ADUs to be allowed. But it does more than that, and I want to kind of point out some of the distinctions, especially for folks that have been trying to use ADUs kind of as a solution for New Hampshire's aging population and for caregivers. So House Bill 577, as I stated, above all else, revises the definition of ADUs to include both attached and detached ADUs, and it removes a lot of discretion that was in the original version of the ADU statute, which allowed for a municipality to determine how it allowed attached ADUs. And now simply says a municipality shall allow one attached or detached ADU as a matter of right in all zoning districts that permit single-family dwellings. So the ADU itself, again, thinking back to the previous slide, House Bill 457, this is again saying the accessory dwelling unit itself as a use, has to be allowed as a matter of right. So it cannot be subject to any public hearing process via conditional use permit. It cannot be subject to a special exception process through the Zoning Board of Adjustment. However, unless the ADU is going to be located in an existing detached structure that existed prior to July 1st of this year, and that ADU is that existing detached structure is being converted into a detached ADU. The ADU still has to comply with all setback, aesthetic requirements, design review requirements, as well as lot size, frontage, and space limitations, as long as those regulations also apply to the single family dwelling. So you, a a municipality cannot have regulations, really, for the most part, at least as stipulated in this list that I've provided, that are only for ADUs. They must apply to both the single family dwelling and the ADU. But if they apply to both, then the ADU still has to comply with those requirements, despite the fact that the use itself is now allowed as of right. I will kind of circle back to that because that can be confusing in a second. The other thing it does is it clarifies that municipalities cannot impose stricter septic requirements for a single family with an ADU than are required by DES. DES has its own subsurface system septic requirements that applicants to build an ADU must still meet, as we'll talk about in a second. And then a few other things here. Partially because statute is now requiring attached and detached ADUs to be allowed, but also just as kind of other issues that were identified in the initial version of the ADU statute. Folks might be familiar. There was previously a requirement about interior locking doors for attached ADUs. That's been removed and replaced with the requirement that ADUs just have an independent entrance or exit through a common space shared with the principal dwelling unit, or through a independent entrance or exit. But the municipality can no longer limit the choice of the entrance or exit to one or the other. That's up to the applicant to determine what's going to be the best. Basically, based on the placement of the ADU, whether it makes more sense or is possible to do kind of the entrance or exit is through a common space or through an immediate entrance or exit to the outdoors. And then a few more changes, as I said earlier. Again, there's additional language that stipulates that the municipal regulations have to apply to both the ADU and the single-family dwelling. The municipality can only require one additional parking space for the ADU. The municipality, however, does retain, as in the original statute, the option to require owner occupancy of the principal dwelling unit or the ADU. And then a couple of other things that folks might have heard about. The size requirements were tweaked a little. The language is a little bit confusing. In essence, the original statute referenced 750 feet. This has been increased to 950 square feet. But the 750 square feet is still in there. So if a municipality was previously said that the maximum size was up to 750 square feet, and that's stipulated in its ADU ordinance, it can continue with that 750 square foot requirement. However, if the municipality does not have has not adopted an ADU ordinance, there are still, despite the fact that the original law was adopted going on 8 years ago, there's still about 24 communities that don't have ADU ordinances. Then for those property owners who can develop an ADU in a community without an ADU ordinance, they'd be allowed to build up to at least 950 square feet. If they wanted to go bigger than 950 square feet, the municipality would have to expressly authorize constructing an ADU larger than 950 square feet. A few other changes I want to point out before moving on. I already talked about the conversion, the exemption from setback and lot coverage requirements for conversion of existing detached structures into ADUs. I also want to point out that There was also new language about only allowing a municipality to apply aesthetic requirements if they apply to both the single-family dwelling and the ADU, where previously a municipality could impose standards requiring aesthetic continuity between the ADU and single-family dwelling. So a lot of ADU ordinances, when they were written, would require aesthetic continuity in paint color, or very common would stipulate where the location of the front door for the ADU might say front door is on the front of the single, couldn't be on the front kind of road, might have to be on the side. So those requirements are no longer valid if those requirements don't also apply to single family dwelling. So there have been obviously a lot of changes in the ADU regulations, but municipal applicant still has to pull a building permit. As I said, they still have to make adequate provisions for water supply and sewer disposal in accordance with the DES requirements. And they still have to have an approved septic design from DES. None of that has changed. Finally, a lot of municipalities have obviously not had a chance to amend their zoning ordinance yet to comply with these changes. Property owners, if they're seeking to construct an ADU consistent with all the requirements, they still may go ahead and apply for a building permit to construct an ADU and comply if they comply with all these new changes, either an attached or detached ADU. Municipalities are going to evaluate differently how to deal with these situations. And other webinars I've given, I've suggested that municipalities consult their municipal attorneys on how to deal with those inconsistencies between what their zoning ordinance says and what an application for a building permit based on the state statute says. But generally speaking, state statute does preempt local zoning ordinance in this case. RSA 631, again, something that I think a lot of folks have heard about. Again, you've heard me talk about the use itself. So this requires multifamily residential development as a use to be allowed on commercially zoned land, which is defined for such commercial activities as retail and office space, provided there's adequate infrastructure, including roads, water, and sewage systems available to support that development. This bill, unlike some of the other bills we've talked about, doesn't take effect until July 1st of next year. So municipalities do have some time to kind of figure out the process and if they want to make any changes in their zoning ordinance to address this. As I said, this statute in 674, Roman numeral 80, doesn't actually define what constitutes adequate infrastructure. So the planning board in each community is going to have to kind of make that determination based on what adequate infrastructure is present and whether they feel that for each application that they receive trying to do multifamily development in a commercial zone, whether there's adequate infrastructure present to support that development. There are some exemptions from the statute. So a municipality does not have to allow the multifamily development use in commercial industrial districts where there might also be industrial manufacturing uses present that might be in conflict with residential uses. And a municipality can also decide that it wants to require all available ground floor space or percentage thereof in an otherwise development which only has multifamily housing to have a retail or other similar use on the first floor. And then finally, the last section of 631 is really interesting. It provides an express exemption for multifamily mixed-use buildings that are being adaptively reused. So existing buildings being adaptively reused. So this are actually exempt from complying with setback height or frontage requirements, provided the building's floor area, height, and setbacks do not change. So as long as the building envelope itself isn't actually being altered in a way that would interfere, change the height of the building, setbacks, they're exempt from other dimensional requirements, such as setback height or frontage. By the same token, this also means that those exemptions from the dimensional requirements don't apply if if a developer wants to put up a newly constructed multifamily building in a commercial district, or for that matter, a mixed-use development. In that case, those setback height, frontage, or lot coverage requirements, minimum lot size requirements, or anything else would still apply. And in either case, a municipality does have the choice to subject those applications to the site plan review process. It's typically something that is a planning board would undertake, typically for any multifamily development. Now, very quickly, getting to our last kind of set of bills here that we're going to discuss today. SB 281 is another one that doesn't take effect until July 1st of next year. This goes back to those different sets of roads. So this is talking about Class 6 roads, which are not maintained by a municipality, are not private in nature, but are not maintained by a municipality, are usually not kept up to the point of being able to support a large multifamily development or other uses. But and may, I'm not going to go into today, but may also be subject to gates and bars in some cases. So previously, and currently right now, the governing body, again, the Board of Selectmen, had to issue a building permit for those, for any buildings on Class 6 roads if the lot had frontage on a Class 6 road. That process, and then it also had to, again, that was after review and comment by the planning board. The new process going into effect next July creates a new kind of waiver process, which takes away the discretion from governing bodies and says that if an applicant basically satisfies the conditions on 1 through 3 here of this basically liability waiver, acknowledges municipality is not going to maintain the highway, it's not going to provide services, it's not going to accept responsibility for any losses, and that the responsibility for any such services falls fully on the applicant, and that it is also proved that they've recorded this waiver at the Registry of Deeds, and also proves that the permit is building permit, the buildings are insurable by a insurance company, then the governing body is required to issue that building permit on Class 6 roads. It's going to be kind of remain to be seen how widely used this is. There's some municipalities will be able to still, if they don't want to issue building permits on Class 6 roads, they can keep doing that by requiring frontage on a Class 5 road or better. In those cases, that would mean that an applicant, as currently is the process, if an applicant wanted to build on a Class 6 road where frontage is required on a Class 5 road, they'd have to apply for a variance before the Zoning Board of Adjustment. So last few bills I'm going to go through quickly. SB 283 just stipulates that for those couple of communities that have this thing called floor area ratio, which measures the ratio of buildings' total floor area to the size of the parcel of land upon which it's built, simply says that basically part of the building that's in the basement it does not go towards kind of that overall kind of floor area calculation if that area below the basement is being used for, cellars, sublevel, basically is not inhabitable space, is being used for parking. This is important because this can take away, kind of reduce how much density an applicant might be able to do in an area, in a community that's using, that's using floor areas to help kind of figure out the volume of buildings on a lot. 284, SB 284, which took effect in early September, amends some of the parking language from last year, with folks may be familiar with. There was a requirement of 1.5 spaces per unit with a couple of, which applied to certain kinds of developments. SB 284 simply amends that requirement to require no more than one parking space per residential unit, regardless of the type of residential development. So any type of residential development a municipality cannot require more than one parking space per residential unit. I will note here, though, that a developer can still apply to the planning board for an alternative parking solution if they can prove to the planning board's or satisfy the planning board that there's demand for less than one parking space per unit, they can propose an alternative parking solution of less than one parking space. Not going to go through the details of that right now, but that process is detailed in RSA 674:16-A. That was a process that was adopted last year in 2024. And then very quickly in our last few minutes on changes to the building and fire codes. So House Bill 428, this again isn't going to take effect till next July, will prohibit municipal amendments to the state building code and fire code beyond amendments related to the administration and enforcement procedures and collecting fees. There is language that allows municipal amendments to technical amendments of the state building code if the state building code is more than 2 additions behind. New Hampshire hasn't been in that situation for several years now. So while that language is still there, for all intents and purposes, municipalities, as of next July, will not be able to adopt technical amendments to the state building code. So there aren't a ton of municipalities that have done this. There's a couple of municipalities that have wanted to adopt a more recent, say plumbing code or electrical code, which might have new requirements that aren't in the state building code. That will no longer be allowed as of next July. The reason for this is simply so that basically there's one standard building code, one standard fire code that both developers and municipalities are working off of. That said, the state fire marshal or local fire chief remains the enforcer of state building code. The local enforcement officer agency, usually the code enforcement officer, will still remain the enforcer of the state building code. SB 188 is titled the Speeding Development Act. This doesn't actually change any language in statute, but directed the Building Code Review Board, State Building Code Review Board, to adopt a new process, which it's done, to allow for licensed or certified third-party professionals, approved agencies to conduct building inspections and construction document reviews in place of local building officials. With this new third-party process, building permits will be required to be issued by the municipal building official 14 days after submission of the construction document review affidavit and payment of application fees by the approved agent. And then certificates of occupancy, and municipalities are required certificates of occupancy, which is it's a little less than half the communities in the state, will be required to be issued within 10 calendar days after submission of the building code affidavit and payment of outstanding fees. As I said, this is a link to the actual processes, the actual amendment approved by the Building Code Review Board, which takes most of the language in SB 188 and just kind of puts it into the official process, the different kind of codes that make up the state building code. And that took effect July 15th. SB 282, this is another one that doesn't make a lot of changes to the actual building code itself, other than saying that residential buildings with 4 stories or less only have to have one stairway if they comply with conditions of the State Building Code Review Board. And this is important because, as folks may know, typically in residential construction, hallways or buildings of 4 stories more have been required to have 2 stairways, which is, as this graphic can show, has created the necessity of having double loaded corridors, which really restricts kind of, in many cases, the design and how many units you can put in a building on a small lot, especially. So the Building Code Review Board's amendment, all it says, and I'm not an expert in building code, but says that this applies to R2 uses. These buildings with up to 4 stories cannot have more than 4 dwelling units per floor. Must be a maximum travel distance to an exit enclosure of no more than 125 feet, and it must have fire sprinklers. But that said, this is still, even with those requirements, should open up some new possibilities for 4-story construction with only having to have 1 stairway. The last bill I'm going to touch on is Senate Bill 4, relative to commercial property assessed clean energy and resiliency, CPACER. So this replaces the commercial property assessed clean energy CPACE statute, RSA 53F, which was on the books since 2010, but was not written in a way which would allow wide adoption and use. So this simply allows for the decoupling of building energy system costs and clean energy improvements from other building construction costs. The New Hampshire Business Finance Authority, BFA, is going to act as a program administrator, providing financing for qualifying energy improvements from property owners. Local legislative body will still need to adopt an energy efficiency and clean energy district where CPACER funding may be utilized. And then, in short, municipality will charge a special assessment to the property owner to pay back the financing they obtain for these energy improvements. But that special assessment is at a lower rate than that property owner would otherwise be able to get using conventional financing, which makes this program financially advantageous and also allows, again, for that decoupling of kind of financing of construction costs for the brick and mortar from all the energy systems. That bill took effect in February. My office is going to be doing a webinar about this with Clean Energy New Hampshire and BFA on November 13th at 12 p.m. There's a link in the slides, which I distributed as well. We'll also be doing additional promotion and more information about that program coming soon. As I said earlier, we are at 1 o'clock. So as I expected, we weren't going to have time for questions. But if folks do have questions, here's my email address and phone number. You should have received a PDF as well. There'll also be a recording today's webinar, which we will distribute as well. And I want to thank everybody for tuning in today.
Well, I want to thank you as well, Noah, for taking the time out of your day, and BEA staff generally for taking the time out of your day to present to the Housing Supply Coalition. We, and especially BIA, thanks you for that. We'll make sure to distribute the slides and the recording once that's finished to the larger Supply Coalition as well, for those who did not have the time to join us today.